Hey, we about to go live. Bam, there we go. Hey guys, we live on YouTube tonight. So we're just gonna cover a couple of things that's very important to people using our jurisdictional challenge with an affidavit. And we're gonna talk about how to properly challenge a jurisdiction and some things that people are doing wrong. But before we get into all that, welcome to Advocates of Justice for Foreclosure Defense Paralegal Service. We are different and we prove it. You guys ready for the weekend? At the weekend. Okay, never mind. Let me stay focused. So today we're going to cover how to challenge jurisdiction. We're going to talk about some important tips and pitfalls that some people are not avoiding. You must avoid these. We're going to review the process for the jurisdictional challenge with an affidavit. And tomorrow I'm going to show you guys the instructional video for the jurisdictional challenge with an affidavit. I'm a little late getting the video out. Spent quite a bit of time getting the document out and rolling, and now I need to catch up with video because some people need some help. So we're trying to put that help together so this process will go smoother for everybody. So let's just jump right in. Oh, wait. Before we get started, I need you guys to subscribe down below so you don't miss anything when class starts. I need you to click that bell up there or over there, wherever the hell that bell is. Click that bell so you get notifications when class starts, because as you can see, I'm not on the schedule. I'm in and out when it's time to go. And also leave some comments. It lets YouTube know that you guys respect what I'm doing and appreciate my service here. And it helps them, know that I'm valuable in their program so they can place more ads. Oh, yeah, that's a new thing. So my YouTube site is monetized now. So I need you guys, if you want to help me, click on the ads. You don't have to watch them. Just click on them and let them play all day long. Okay. I hope YouTube's not listening to me. I guess it really don't matter as long as that ad's clicked on this and it's playing. I get paid, and so do they. They get paid, then I get paid. I'm down the list, and I'm all right with that because at least I'm on the damn list, so we good. So the first thing we want to talk about, and this is like when you're challenging jurisdiction, the first thing that we need to cover tonight is the judge is not the party who must prove jurisdiction. Hell no. The judge is not the party to prove jurisdiction. And if the judge takes it on him or herself to dismiss your shit, then it's on. And I got the new claim against the judge specifically for violating your jurisdictional challenge with an affidavit that you can use now. And I had it marked low half price at $200. And I think it's like 4 or 5 documents in that. We'll go over that tomorrow too. The judge is not the one. Hey, Che Dolly. The judge is not the one to challenge jurisdiction. Okay, that's the biggest mistake. One of the biggest mistakes that people are making. Jurisdiction must be proved on the record by the party who filed the case in court. So whoever's bringing the case forward, that's the person that's got to prove jurisdiction. Now, in my jurisdictional challenge with an affidavit, if people read the document, you'll see right on the front there that you are directing the judge to order them fools to prove jurisdiction, not for the judge to do it. And remember, if you file my jurisdictional challenge with an affidavit, they have to respond by counter affidavit or they have not responded. And they can't respond by counter affidavit because they're lying and everything they're doing is bullshit. And they cannot respond by counter affidavit. And I've told you guys that. I'm telling you guys again, they can't respond by counter affidavit. So you should already know what you need to be doing next. And that document that you need to file next should already be ready to go. And you should be counting down the days. Now, all this starts by you checking the federal rules of civil procedure and finding out what the time frames are that they had to respond. finding out what time frames are for filing the motion, finding out what the judge is supposed to be doing. I had one lady tell me, oh, I'm going to go to the court and get those off the website. No, dude, there's two sets of rules. There's the set of rules that's entwined with the Constitution that are mentioned in the Federal Rules of Civil Procedure. Those are the rules that everybody are supposed to be following, including the freaking judge, okay? Now, there's another set of rules. It's called the local rules. The local rules are rules by each court that set, local rules are rules each court sets for themselves. They have not gone through the legislative structure to be considered legally binding. They are not in line with the Constitution, and they are for attorneys to follow. Now, these local rules speed things up through court. So you already know, anytime the court process is being sped up, they're stepping all over your rights. So that's the way that goes. You must know which rules are the rules that you have to follow. And you must know which rules, what rules to follow, and follow them. And when these fools get in your face with this other crap, you need to let them know, hey, my legal team already went through the civil rules procedure, and this is what we came up with. And if there's something else that's connected to the Constitution that's been voted on by the legislature that I'm supposed to be following, you show me where it is, and I'm gonna take it back to my legal team and let them look at it. And by the way, I'm gonna need your name and your bar number, because my legal team may want to add your ass to the list. Okay, I'm getting a little carried away here, but hey, what the hell? The quicker you convince that clerk at the gate that you ain't playing, the less crap they're going to be giving you. Now, if the judge interferes before the attorney proves jurisdiction, he is doing so acting outside of the law in his own or her own personal capacity. Now, people always ask, oh, the judge has immunity. No. The judge has qualified immunity. To qualify for that immunity, the judge has to follow the law. And they're not following the law right at the gate because they're having an administrative hearing for you, not a judicial hearing. And we'll talk about that at a different time, because I don't want to stay focused on the jurisdiction issue right now. So people will be able to do this better in court and put themselves in a better position and not have to be playing catch up. Now, I had one person removed the affidavit part of one of the jurisdictions that he filed, and I don't get it. You know, I don't get it. I'm like, okay. So what you need to do, what you need to remember is, if the judge dismisses the jurisdictional challenge with an affidavit or your jurisdiction challenge, the judge opened himself up or herself up for civil liability. And what we're learning how to do is cut to the chase. So when the judge jams you up, you need to be jamming up the judge and stop playing around, okay? Because it's not going to do any good to keep filing more stuff and to keep doing these things and then just keep playing and act like the judge ain't the one violating you. As soon as the judge violates you, the paperwork is here. You need to get that documents and get them stuck in the judge's face ASAP. Because you know what? At the end of the day, it don't matter who you're suing. If you're suing the judge, the clerk, the freaking mail driver, it don't matter. Whoever is the one that's blocking you from having your day in court, that's whose ass need to be on your claim. So you need to keep that in mind. So the way they work this jurisdictional challenge is, once you challenge jurisdiction, you cannot argue anything else. You cannot argue anything else that you're not claiming in your jurisdictional challenge or in your jurisdiction, your challenge, your jurisdiction. You can only argue what's in the challenge of jurisdiction. If you argue other stuff, you're bypassing your jurisdiction challenge and you're allowing them to ignore it because you're moving on to the next order of business, and they want to move on too because they ain't trying to listen. They have to worry about challenges. They ain't got an answer for that. So once you challenge the court's jurisdiction, you cannot allow the court to move forward and ignore your challenge. And we're going to go over a couple of ways that they do that. So the judge will get you to move forward and bypass your jurisdictional challenge by getting you to focus on the payments in court. Now, the judge knows that the payments are going to bring out emotional reaction, And when you start talking about the payments, then most people revert back to the lender didn't have an assignment and all of that cruddy stuff that is talking about the actual banking system. That stuff is not going to help you in court. And I'll tell you why. That stuff's not going to help you in court because it's not the lender that's suing you. Okay, by the time you get to foreclosure process, it's a third-party debt collector that's trying to stick their hand in your stuff. Okay, that's what's going on. It's not the lender. And if you go into the court talking about all the stuff that has to do with the lender, they're just going to let you stand there until you run out of money and then throw your butt out the door because they know you have no idea who it is suing you, and there's no way in hell you're going to be able to get the right person in court, and it's going to be a waste of their time. They know that. So the judge is going to get you to talk about the payments. He wants you to talk about the payments. And if he can get you to start talking about the payments, then the judge is going to conclude that there was contract, even though there's not one filed in the case. And even though they don't have a contract, because the contract has to be signed by two people. And what they have is only signed by you. Nobody from the bank signed it. So they don't have a contract. But if they can get you to talk about it and act like it, then they'll just say you do have one. And most people get emotionally charged up when they start talking about the payments because you start thinking about how bad you've been getting screwed. And now you lose thought of all the stuff that you should be talking about that's in that jurisdictional challenge with an affidavit, which is the stuff that got you in court in the first place. Next, the judge will get you to agree to make payments. Yeah. I had a lady tell me the judge got her to agree to make payments. I'm like, well, why the hell would you do that? Because the judge was telling me, okay, just what can I do now? Okay, we'll work on that. The judge is going to get you to agree to make payments. If he can get you to agree to make the payments, now the judge will conclude that you owe the money. All of this trickery is going on, and you have no freaking idea. And you're there thinking the judge is going to be fair. Well, hopefully, if you're in my program, you'll know the judge ain't going to be fair because you already figured that shit out, or you wouldn't be here looking for some different way to try to save your shit. So hopefully, you already know that if you're in my program. The problem is you have no contract with the third-party debt collector. Okay. You have no contract with the third-party debt collector. So when the judge starts asking these stupid-ass questions, then you just tell them, look, my legal team already reviewed the paperwork, and I have no contract with the third-party debt collector. The third-party debt collector is a person who signed the documentation to initiate the illegal foreclosure against my property. That person does not have standing. I have no contract with the third-party debt collector. And the next thing that happens is you will be invited to inspect the note at the attorney's office. Oh, excuse me. You'll be invited to inspect the original note at the attorney's office. Yeah, I fell for that shit too. So don't feel bad if you fell for that because that was a long time ago. So here's the deal with that. Why the hell is the original not filed in the court? Because that's what the court needs to have jurisdiction. Not only do they need the original contract, they also need an affidavit from an injured party, and they have none of that. Say, Dolly says, once challenged jurisdiction, we turn into plaintiffs. No, that's not right, say, Dolly. So the plaintiff is the person who actually paid to file the action in court. That's the best way to look at it. Plaintiff is a person who paid to file the action in court. Defendant is the other person, the person who got dragged into court who didn't pay to be there. So that's the best way to look at that. So the judge, the attorneys, and the clerk lie to you to steal your hope. That's why they have all those nonsense hearings going over stupid stuff. Okay, that's why the judge and the attorneys attack your ass in court. And that's why they go out of their way to make you feel stupid in court. That's why the payoff amount keeps growing larger and larger day by day because they're trying to steal your hope. And it's a psychological game that they play on YouTube, because if they can steal your hope and get you in your head to give up, the rest is just gonna come. Because once you give up in your head, the rest of it's gonna come, because you're just not gonna fight. You're gonna be saying, oh well, there's nothing I can do. I better get home and pack my shit before they come and throw my stuff out on the yard. And a lot of people do that. A lot of people do that. And most of the time it's done out of fear. And I'll tell you right now, I don't work well with fear. I don't work well with people being pushy. I don't work well with drama, because I don't need it. I don't need the drama. And now I realize that this is a very stressful situation. Anytime you guys need my help, it's usually stressful, because you got some attorney trying to steal your shit or take your money, or both, or throw you in jail. I mean, we don't want to just end with that. And I realize that. But there's going to be times when you're asking me stuff, and I'm going to tell you, you need to go figure it out, because my job is not to make it easy for you. My job is to help you learn how to stay in your house, have you learn how to kick the attorney's butts. And the best way to learn that is to go do it and figure it out for yourself, so you remember it the next time. Otherwise, if I just start telling you what to do, that's what we're going to have. It's kind of like when you have a business. If you let your employees handle shit and get stuff done, then when you're not there, shit's going to get done. If you micromanage and run everything and tell everybody what to do, when you're gone, nothing's going to get done, because no one's going to know what to do. The idea here is to learn the documents in your package, to learn the strategies behind using the documents, and to put together the game plan that you need. Now, there's a big difference when people come to me and say, hey, this is what I got from the court. I reviewed everything, and I looked up all the words I didn't understand. I Googled them, and this is what this document means, I think. And this is what I think I need to do to defend my property. I need to file this or that and this, and that gives me an opportunity to see if you're growing or not. It gives me opportunity to see where you're at now, and I can step in and say, hey, yeah, that's a great idea. You want to do this like you said, but this part you might want to wait or whatever over here. That's a lot better conversation for me than how people come, what do I do? I don't know. You tell me. Another thing that I get is people that's in the program, if they miss a few steps and their situation gets dragged on, I don't remember everything that we agreed to do and what they've done and all that. That's why it's so important for you guys to take the ball and start looking at this from day one. Okay, let me figure out what I need to do. I need to file it. They need to respond. I need to default them if they don't respond. All of this stuff you can find on the civil rules, the federal rules, civil procedure. You can find it Googling stuff on Google. You'd be surprised at what you can find on Google. Yep. You can even find other people's lawsuits on Google. Sometimes I'll look on Google if I'm working on something. If I can find an opinion from the judge, then I can use the judge's opinion in my conclusion. Nice. Okay. I know. What the hell? It works great. Use the judge's opinion in your conclusion. Now, if you're going to do that, then you want to go ahead and learn all the other stuff so that you can incorporate all of that in your document. Oh, now you're learning how to put the document together. This is the mindset I need to have people in. This is the mindset people need to be in if you want to be in my program, okay? You need to be in the mindset, I'm going to learn how to put these documents together. I'm going to learn how to put this stuff together and stick it right up in their face. That's a big difference than what do I do next? So you need to remember that. This is a free tip that I'm giving you guys. Now, when you guys learn the rules, the federal rules, civil procedure, those are the rules that all the parties are supposed to follow, including the judge's ass. So, and remember, those local rules are for the stupid people. And if they can get the stupid people to follow the local rules, stupid people won't last in court very long. Now, this is a huge tip. Never wait for the judge. Never wait for the judge when the attorneys have failed to respond. Okay? You should be checking in the federal rules of civil procedure to find out how long they have to respond to your document, to your pleading. And you should already have the damn document put together that the default document you need to stick up in their face when they fail to respond. Because I'm already telling you that they're not going to be able to respond. Now, I got people waiting for the judge to respond to your jurisdictional challenge with an affidavit or your jurisdiction challenge. Oh, hell no. You don't wait for the judge to respond to shit. People don't realize you need to default them, even if the judge says it's okay. They don't have to respond. Default their ass anyway, because they do have to respond. They get out of responding if you agree with the judge and you don't do something about it. Okay, that's how you do that. You default them anyway. Don't matter what the judge says, because you don't have to agree with what the judge says. And remember, the rules mandate that they must respond in the time frame. You need to figure out what that time frame is and make sure that you're on that. You have the right to reply to their response before the judge gets involved. This is something that most people miss out on. Bar members skip the process of replying to their document when you fail to reply to the court considers that you left the playing field and they grant everything to the other side. So if you got attorney work, and you think about this, I bet some of you are going to be saying, oh, damn, yep, you filed something, your attorney files this badass document for you in court. Yep. The other side responds, and then the judge dismisses your stuff. Well, the attorney knew that you had no idea you were supposed to make your attorney reply to their response. And when you don't do that, that means you left the playing field early and the other side gets granted your shit. And what happens is the attorney says, well, I don't know what the hell's wrong with that judge. That judge is full of crap and doing that shit. I don't, yep. And then the judge said, well, the attorney was the one that should have done that. The whole time they already agreed to this shit before you got to the hearing that they were going to do this to you. That's how that goes. Now, this is how a lot of people get thrown under the bus by their attorney. They get thrown under the bus. Hey, Phil, how you doing, buddy? They get thrown under the bus because they trust the attorney and they never look and find out what the hell the attorneys are supposed to be doing. And they never get like a PACER account. If you're in federal court, you should have a PACER account. If you're in state court, you should be pulling a copy of your docket sheet once or twice a month, depending on the activity. Now, Shamel Maxwell, she's one of my lead scoring team members in the group, and she has used the jurisdictional challenge to stop her dad, to sell her dad's house like 4 times, and to vacate the judgment. And she's still at them because they still keep trying. I think they split the money up already and they're having a hard time standing down. But we're making it difficult for them because we're learning how to cut to the chase. And when we cut to the chase, that means we're holding people responsible that's up in your way. And that's how we do it. It don't matter who it is. If the judge is in your way, then the judge needs to be held responsible. If the clerk's in your way and blocks you or files some stupid crap or whatever, then the clerk needs to be added to the list. It don't matter who you sue, as long as you're holding somebody responsible at the end of the day for throwing you under the bus. That's how we roll. Now, we need to remember their whole program is to steal your hope. They want to steal your hope and use the fear to paralyze you. Hey, Gloria, they want to use the fear to paralyze you. Now, at the end of the day, as soon as the judge violates you and dismisses your jurisdictional challenge with an affidavit or your challenge jurisdiction or whatever, if the judge dismisses it, you need to address it with the judge, because we have one person that didn't address it in state court, went ahead and filed stuff in federal court. Well, they talk. They get on the phone, call each other back and forth. So as soon as the federal court got this stuff and found out it was already filed in the state court, they're on the phone to him. And the people in state court tell him, oh, dude, don't worry about it. No, he filed his badass jurisdictional challenge and we just smashed him and dismissed it, and he didn't do nothing. He went and started filing stuff over there. So he don't know what to do when you throw his shit out. So don't just if he files some stuff in there, just mess with him. I'm sure that's what you tell him. Think about it. So you guys need to remember, when you're challenging a jurisdiction, you cannot bring up a bunch of other stuff. I had one guy tell me, yeah, I found my jurisdictional challenge, and then I had oral arguments, and I argued some case law that pertained to my situation. I'm like, oh my God, dude, you just shot yourself in the foot. Anytime you argue their case law and their stuff, then you're bypassing your jurisdictional challenge and you're allowing them to move forward to the next order of business, which is back to the fraud. Okay. And you can order the fraud all day. The whole mortgage thing started out as fraud. And this is one of the things that people don't realize. Okay. The two things that you have to separate when you're fighting a foreclosure situation. Okay. The illegal mortgage fraud was one thing. The illegal foreclosure is a totally different thing. And the two different things have different actors in them. And sometimes they have the same actors, but most of the time they have different actors, because the mortgage and all that crap and the mortgage fraud is done by the bank over here. And then the bank does a charge off and claim it on their taxes. And then they sell your alleged debt to third-party debt collectors for pennies on the dollar. And we know that, well, I know that that's the problem. They're violating the law, because if anybody that has any understanding of the GAAP accounting principles will know that once you do the charge off and claim it on your insurance, claim it on your taxes, there's no entry places available on your books to put any additional income. And through the conspiracy statutes, all of the parties are guilty of the same fraud from the original party's fraud. So the real estate deed fraud, the illegal mortgage, the illegal lien put on your property, all of that stuff. Yep. And the reason it becomes real estate deed fraud, and we're working on a document for that, because that is the beginning of this. The real estate deed fraud comes into play when you purchase your property. Each state's real estate transfer laws mandate that deed is supposed to be delivered to the new owner, to the buyer, to the new owner of the property. But you didn't get your deed delivered to you, did you? Did any of you get your deed? Hell no. Nobody gets their deed. What these dudes do is they take your deed and they do what they consider a constructive delivery. And they record your deed in the county recorder's office. And the first lien that's put on your property after they record the deed, does anybody know what that is? I'm going to tell you. The first lien they put on your property after you record the deed is the mortgage lien against your property. Now, your property was paid for with your signature when you signed the promissory note. When you signed the promissory note, they took that note and they turned it into a security, and they process it through the Federal Reserve for the electronic credits that they're saying is the alleged loan that they loaned you. But they never loaned you. They never made you a loan. And actually, the Modern Money Mechanics publication states that they were actually paid 9 times the amount in a demand deposit account when they process your promissory note through the Federal Reserve. So that alleged loan was created with your own signature. Now, hazard attorneys argue with me especially when I post the eliminate property tax lawsuit package, and they want to argue with me because they don't like everybody knowing the real deal. So they'll come in and they'll start arguing with me and making a big deal. But here's the deal. if you have owners of property that are selling the property or taking out a lien against the property or filing a lien against the property or whatever, everybody who owned that property would have to be there to sign the lien, right? Right. Okay, I'm talking to myself too. Right. So the fact that the bank accepted your signature on the lien for the fact they accepted your signature on the lien against the property, on the mortgage lien against the property, shows that you own the property free and clear, or they would not have been able to accept your signature. Chew on that for a minute. I like to keep it simple. And I'll tell you this, the eliminate property tax lawsuit package is really not about eliminating property tax. Well, it kind of is, but that's not the main goal of it. The main goal of that lawsuit package is to help you get control of the deed to your property, to help you get it back so you can put it in your Bible where it is supposed to be, where people used to keep their deeds all the time until these attorneys got together and started doing all this stupid shit. And if you think about it, once your deed's registered in the office, now who has access to it? Anybody has access to it that wants to put a lien on your shit. Yep. Anybody has access to it. Now, this is the scary part. I have people in my Facebook page that have all of the documents to show that their lien has been paid off. They have the deed release, the lien, they have everything, but they're in foreclosure. So how the hell does that happen? How the hell can you be in foreclosure when you got the paperwork showing that you paid everything and you don't owe anybody anything? Well, what happened is that these attorneys go to the county recorder's office and they copy down your property information, and then they go back to their office and they fill out a fake assignment, and then they just file foreclosure against you. They know that probably 70% of us are struggling. They know 80% of Americans can't afford an attorney. And if you can't afford an attorney to help you with a foreclosure issue, it's not going to be for very long before you run out of money and the attorney throws you under the bus. So they have an 80 or better % chance of stealing your property just by getting your information and filling out a fake assignment and sticking it up in your face, because most people don't know what to do. And if you're in a non-judicial situation, holy crap, you have no time to be getting things together. And once they serve you the thing in a non-judicial foreclosure in like 30 days, they could be selling your house. They do it all the time. So that's how that rolls. The eliminate property tax lawsuit package is more about getting control of your deed. But here's the funny thing. If I said, hey, we're going to help you get control of your deed, most people would say, I already got control of my deed. I have a file in the office over there. They're taking real good care of it for me. Anyway, you guys get the point, right? Hey, James Galley. So that's all I got today. We're going to be back on here tomorrow. I'm going to have, providing I get everything done, I'm going to have, we're going to review the instructional video for both the jurisdictional challenge with an affidavit and the new packet that I put together, the claim against the judge for specifically for dismissing your jurisdiction without judicial authority. Hey, MYX Capital. Contract is law. Well, the funny thing is that what they're sticking in our face now, the revised codes and statutes, is not law. It's their own policies, and their policies have not been put through legislative scrutiny, nor are they aligned with the Constitution. So they're not shit that we have to follow. The statute that they use in both judicial and judicial foreclosure is actually, it's not a valid law, because it does not have the enacting clause, it does not have a title, and does not have a body. And each constitution mandates that a valid law have these things. And people ask me, so what does that mean? Well, that means that statute they're using to give the court authority is BS, and the court don't have authority, and they're operating without jurisdiction. So, well, that's all I have tonight, guys. I will see you guys tomorrow. Yeah, MX Capital says statutes only apply to sellout citizens. Yeah, well, the thing is, the citizens don't realize they're citizens. Actually, they do, because they claim themselves as citizens of the United States, the federal government. But the fact of the matter is, nobody can be a citizen of a fictitious corporation. So nobody can be a citizen of the U.S. government. You have to be a citizen of the United States of America, or some other country, or Providence, or whatever. And that's real important that you bring that up, MYX Capital, because when you can verify that you are a state citizen of the Republic state you were born in, you are no longer subject to the statutory jurisdiction of an administrative court. Matter of fact, you're not subject to statutory jurisdiction of any court unless there's an injured party. And in foreclosure, there's no injured party because the action has been filed by a third-party debt collector. Lying and hiding behind the fact that he's working for the lender, but the lender don't sign nothing. So, yeah. Anyway, thanks, guys, and I'll see you guys here tomorrow.